Thank you.
Madam Chair, may I respond briefly to Mr. Short?
Could you, other parties who are present today, do you want to be heard on any of the matters?
Thank you, Madam Chair. OER would just like to say we'll be happy to issue a supplemental advisory opinion. We also feel that we can make our updates through the final hearing process through our expert witness testimony and the cross-examination of our expert witness. Thank you.
Thank you, Greg Mancini with Rhode Building Trades. We don't have any substantive comments on any specific matters, except to say that, our members would like to see this process move along as expeditiously as possible, and so that our members can decide for themselves their future work opportunities. Thank you.
Thank you, Madam Chairperson. A couple of things very briefly. It's clear from Mr. Shore's comments that Invenergy and CLF disagree about whether or not this is the same project and how complicated the new design is. That's why we're suggesting that the EFSB hire its own independent engineering expert. Second, with regard to the water plan, Mr. Shore characterized the new plan, in his words, quote, vastly simplified, unquote. He used that phrase at least twice as a characterization. What we know about the current water plan from the record is that it's not Invenergy's first choice for water. That was Pasco Utility District that turned it down. This water plan was not Invenergy's second choice for water, because that was the Harrisville Fire District that said no. The current plan is not Invenergy's third plan for water. That was the Woonsocket City Council turned that request down by a vote of 5-2. So the current plan is not Invenergy's first or second or third choice. You should ask yourselves if this water plan is, quote, vastly simplified, unquote, and so much superior to the others, why it wasn't the first choice. On the matter of the PUC, Mr. Shore said that CLF just wants to make the same arguments. No, we don't want to make any arguments about need before the PUC. We want to present facts from the ISO that did not exist last July 25th at the time of the hearing, results of reconfiguration auctions, results of FCA 11, and the 2017 CELT report. We don't want to rehash old arguments, we want to present new evidence. Finally, Mr. Shore characterized the General Assembly's purpose in enacting the Energy Facility Siting Act in 1986 as speeding permitting along. I respectfully disagree. The genesis and etiology of the Energy Facility Siting Act in 1986 was that the General Assembly recognized correctly that it was getting difficult to permit large energy facilities as a result of NIMBYism, not in my backyard. And the statutory scheme, taken as a whole, is a two-part bargain. In the first part, legal permitting authority is taken away from a plethora of state and municipal agencies that otherwise would have had permitting authority but for the Energy Facility Siting Act, and placed that permitting authority here with the EFSB. And then the second part of the bargain, inextricably linked, was that the EFSB was to get advisory opinions from those agencies that had been divested of their authority by the statute, by the 1986 statute. In that overall context, it would be going against the intent of the General Assembly for you to proceed without asking those municipal and state agencies for advisory opinions, particularly in light of the degree to which we have a new proposal. Finally, on the matter of asking for advisory opinions of an agency that may not want to give another advisory opinion, under the last sentence of Section 9A of the statute, the Energy Facility Siting Act, I'm sorry, it's Section 10, not Section 9. Thank you, Mr. Green. The last sentence of Section 10A of the statute, agencies that are asked for an opinion that don't want to give one can say that and waive the right to do so. That's contemplated in the statute. That's not a reason not to ask.
Excuse me, I have just a few responses. First, I'd like to address the issue, which I think has become a little bit confusing. It was discussed briefly at the last meeting that we had here, and that is, what is the authority of the board with regard to requesting advisory opinions from both jurisdictional agencies and non-jurisdictional agencies? And I think there was some discussion that may have been misconstrued with regard to the distinction between the two. Clearly, for those agencies called jurisdictional agencies that would otherwise have had permitting authority, that's something you absolutely have a statutory right to ask for. You are the ones that render those decisions. Those final decisions are yours now, and that's the way that the process works. But there are also non-jurisdictional agency decisions that you have the discretion to ask for opinions on, and it is traditional that the Energy Facility Siting Board determines which non-jurisdictional agencies would be appropriately approached. So, for example, returning now to the preliminary order that was issued in this matter, the sections were broken up into A, jurisdictional agency requests, and B, starting on page 15, non-jurisdictional agency requests. And I just want to quote from two sentences in the non-jurisdictional agency introduction. It says, "The board has both the obligation and the authority to request further," read, not just from jurisdictional agencies, "advisory opinions from agencies other than those, absent the Siting Act, who would have specific authority over the proposed facility. In addition to the mandatory opinions required from the jurisdictional agencies by the Siting Act, the board, in its discretion, may, and hereby does, request informational advisory opinions from the agencies listed below, for which there are no applicable license, permit, assent, or variance proceedings required for the facility." End quote. Again, that's on page 15. So some of the requests that we are making are going to jurisdictional agencies, and some of our suggestions in your discretion will go to non-jurisdictional agencies, which you have in your own words, both the authority and the obligation to request if you feel that their opinions would be helpful to you. So to the extent that my brother is arguing, oh, don't bother going to Johnston or Smithfield or Gloucester, we don't really think they've got much to say, I agree with my brother. Let them tell you that. We think they are non-jurisdictional agencies, and you should see what they've got to say, if anything. If, as my brother said, they have nothing to say, they'll tell you that. With regard to the Public Utilities Commission, again, Mr. Shore argues that there is no new evidence. I respectfully disagree. We know about the second rejection of Unit 2. We also know that for the first time that I'm aware of in recent history, there were no new fossil fuel plants picked up in the auction, not one. And why is that? It's because there was an unexpected and frankly huge amount of energy efficiency and demand reduction that was picked up in the auction. In fact, as the testimony of Mr. Walker shows, the energy efficiency and demand reduction amounts picked up increased by 72% over the auction from the previous year. In addition, there was a huge amount of behind-the-meter solar that was picked up by ISO New England. That amount increased in 1 year by 84%. This is clearly new information. This is a change in direction at the ISO New England that we think either you can consider if you would like, if you think that's the way to go at the final hearings, or we can get a first look at it before the PUC and let them know what this new information is and see whether or not they think it would affect their recommendation to you. He also mentioned that 30% of the capacity could be gone. Well, that's a red herring. The ISO very clearly has already considered all expected retirements in its awards. Are there expected retirements? Yes. Have they been considered? Yes, absolutely. Did Invenergy get an award the second round? No. With regard to costs, my brother seems to indicate, well, you don't need to look at that. There has been, I believe his words, if I wrote it down correctly, there is a little bit of a disconnect, I think was the quote, between looking at costs and what the statute says. Well, I respectfully submit that the statute has not been amended. And there have been many opportunities to amend the statute, and it has not been amended. This board must act in accordance with the statute. And in fact, this board intends to do so. Again, returning to the preliminary order. Page 9, subsection Roman 5, issues to be considered at the final hearing. Issue 1, is the proposed facility necessary to meet the needs of the state and/or region for energy of the type to be produced by the proposed facility? Public Utilities Commission, with the participation of the Division of Public Utilities and Carriers, OER, and the Division of Planning and Department of Administration, must render a single advisory opinion on the need for the project and whether the project is cost justified. It goes on to say, the PUC's opinion must specifically consider the need for the project based upon projected cost. Issue 2, is the proposed facility A, cost justified, and can it be expected to produce energy at the lowest reasonable cost to the consumer? That's the heading. Under the 2A, is it cost justified? This board said, quote, the evaluation of the need for the project will expressly include whether the power from the facility is needed at its projected cost. In rendering its opinion, the PUC must specifically analyze the projected cost impact of the facility upon Rhode Island retail electric customers under a wide range of reasonable factual assumptions involving the types and costs of fuel to be used. The PUC and the board must also specifically consider respective costs to retail customers of power derived from reasonable alternative sources. The question is, do we want to go into that? First of all, we have to go into that analysis. You've already ruled that. The statute requires that. Your ruling was in accordance with the statute. For my brother to suggest, hey, you don't really need to look at cost anymore, the auction establishes the price, let's move on, is contrary to the statute and contrary to this board's order. Finally, with regard to experts, my brother has argued, and correctly so, that this board has discretion with regard to experts. We agree with that. We think an expert should be hired by this board to evaluate the water plan and its various impacts. But as we've suggested, we also think the board should give serious consideration to whether any other experts should be hired. The complexity of the need analysis, the cost analysis, the socio-economic impact analysis, and the environmental impact analysis is something that I think cries out for an independent, unbiased expert to look at these various issues, expert or experts, to look at these issues, who are not beholden to any one party, but are beholden only to this board to render a completely objective opinion. We have already, as I've said earlier, gotten involved in the weeds. I think the idea behind the way advisory opinions were structured is that the weeds will be sorted out at the advisory opinion level. Where we are now is we've had a substantial break. There's been time that has passed. Multiple additional documents have been filed that affect all of the analyses that have gone before by the various advisory opinion agencies. We respectfully submit that these agencies be asked to review this additional information and render either supplemental or new opinions to this board so that this board can move forward, and that this board should give serious consideration to whether it would like the help of objective experts. Thank you.
Is there anything else? So I'll ask my fellow board members if you want to discuss the two motions that we just heard. Now, we have 5 minutes until the open meeting is supposed to start.
Again, I just want to thank the town, verbal, CLM, and Energy for the informative arguments. But as far as I know, we do not have to make a decision on these motions right now, and it's the sole discretion of the board to ask for additional opinions. We do have an open hearing scheduled for that. Additional opinions.
Can you move the microphone, please? We can't hear you.
We can't hear. Hold it closer to your mouth.
Can you hear me?
Yeah.
Mr. Agarwal, or do you just mean to discuss them at 3 o'clock when we turn, because we still have a period, Madam Chair, where we can ask any questions of the parties on the motions, correct?
Yes.
Okay, and is that what you're referring to?
Yes, we will
Okay.
discuss the issue of additional advisory opinions in our open meeting.
Did you have questions for the parties?
Thank you all. I don't think I have additional questions. I think I'd be ready to turn to the open meeting now. We're at 3 minutes.
Okay, do you want to take a break now? Actually, I think I had a couple of questions, but I can look at them. Okay. Okay, first I have a question, and I think that this is directed to Borough about Providence Water Supply Board was asked in its recent rate case specifically about the very questions that have been discussed that would be asked of it. And I believe Providence Water Supply Board was represented by the same council at that time.
Yes, I represent it.
Can the board take administrative notice of those questions and answers from the Providence Water Supply Board?
In my opinion, of course, they're all a matter of public record. They're open dockets waiting a decision before the Public Utilities Commission in this building, and I think it's perfectly appropriate for this board to take administrative notice of anything in that time.
Thank you. And in Venergy, how do you respond to the town's query regarding the additional information that DEM had indicated that it was or might be necessary to its consideration of the matters before it?
Yeah, this was regard to the data question that he was referring to. Yeah, I think what he failed to point out in the response to the data question was that we, in Venergy, highlighted the characteristics of the survey, not survey, but there was the site-specific data that were identified in site visits that were made at the time the application was being put together, number one, and also highlighted the references in the application. That number two, that there's the wetlands application permit process, which is shortly about to be prepared and filed, I believe. And that has an extensive amount of information with regard to biodiversity or with regard to site characteristics of the site. That's going to be reviewed by the agency at that time. Third, that the...
And that's separate from this proceeding?
Yes, the wetlands application process will be a permitting function of the agency that will be undertaken together with the transmission line piece of it, the national grid piece of it. We also want to point out that we'll be meeting with the agency shortly to review the information that was in their advisory opinion, and that if additional site materials or site data would be helpful, Invenergy is prepared to go out and go on site and do that. But I do point out that there's a seasonal aspect for that. That type of information would not have been really useful to go out, say, in December, January, February, obviously with winter. We'll be looking at species. With the spring, we're just hitting the time now where that information, or at least that the data points, I think, would be more relevant to be out on the site. So that is information that we will be meeting with the agency. We're meeting with the agency as part of that permitting review process to make sure we comply with all the requirements.
Given that it is under the Act, the applicant's responsibility to show and to the board can only grant a license upon finding that the applicant has shown, among the other listed matters, that the proposed facility will not cause unacceptable harm to the environment. I'm concerned that if DEN does not have the information to render its advisory opinion, how can the applicant make that showing?
Yeah.
Yeah, I think the information will be available to the agency within the next, so during the time frame under which if they're going to be reviewing this next agency advisory opinion process. If there is information in the wetlands application, they'll have that in their hands certainly during this time frame before we get to final hearings. So that would be available to them. And again, the agency does have the site characteristics that were identified in the application with regard to the species habitats that were identified originally. And if they would like to see more information, we're prepared to work with them to meet their requests.
And was Invenergy objecting to or not objecting to the request for additional information from the Department of Health?
Yeah, with regard to the Department of Health, we weren't objecting to the request to get any updated information that you think is necessary or would be helpful from the department We were just suggesting that the information that they were indicating they wanted to see with regard to that water treatment or the water treatment project is no longer at play. It's no longer the relevant concern with the revised water supply plan that we have now before the board. That was, I think, the primary area that the Department of Health was left unable to advise with regard to that water resource piece of it.
Thank you very much. I don't think I have any further questions.
I actually thought of a couple. I want you both, all three of you parties talked about getting an advisory opinion from the town of Johnston, and I think Mr. McElroy did a good job of talking about jurisdictional and non-jurisdictional. Which entity within the town of Johnston were you recommending? And you may have different answers to that.
I can say on behalf of Burrillville that we recommended that they approach the planning board and the tax assessor. The planning board for consistency with the comprehensive plan, the tax assessor for any adverse impacts of the trucks traveling through town.
And our recommendation would be for the town, officially the town council, or the Department of Public Works. That would be the entity that actually controls the water system of the town, and that would be the relevant town entities that we would think would weigh in or listen to the water supply aspects of the project. Because we have a municipal agreement with the town council, with the town and the company that was authorized by the council, and that the water supply would be, the technical aspects of it would be under the Department of Public Works.
This was not in CLF's written submission, but in my comments today in regard to Johnston, I said planning and taxes.
And Mr. Elmer, I think it's obvious from your heading, and you talked about the still missing original advisory opinions. Then you did footnote that for health, which you specifically talked about. But it was a little bit confusing because we did have advisory opinions from DEM, several of the agencies that you talked about is still missing. So I think what you're referencing, and you just had a dialogue here about biodiversity and ecological issues, were the aspects of those opinions where the entities said they weren't able to comment because they lacked sufficient information.
Yes, that's correct, and that is before the board in CLF's two written motions pertaining to dismissing the docket on that account, where we outline with specific citations to the record where those agencies said they were unable to do complete opinions. We do recognize and appreciate that the motion to dismiss on that ground was not granted, and we are now suggesting and respectfully urging that those agencies be asked to complete and fill in what was missing. And just to be clear, at the bottom of page 2 of the currently pending motion that's before the board for argument today, what we specifically said was 3 things should be done. One is the 6 agencies should be directed to submit to Invenergy data requests that, if answered fully and fairly, would enable the agency to provide complete advisory opinions. Second, Invenergy be directed to respond fully and fairly. And third, the agency then provide the advisory opinion to the EFSB. And if each of those 3 things has a date certain attached to it, we've got a plan to go forward.
I don't have more questions, Madam Chair.
All right, then we'll take a break now. we're taking a break. Are we adjourning the hearing? But, and then we go right into the open meeting?
Do you need a motion to adjourn the hearing? I'll move to adjourn the hearing.
Second.
All in favor? Aye.